many M&A transactions, focusing on due diligence and drafting the technology, IT, IP, and data privacy areas. So we're very excited to have Jason for the next hour and a half. And one kind of housekeeping note, if you have any questions during the presentation, please feel free to either pop them into the chat and I'll make sure Jason sees them, or if you want to unmute yourself and ask a question, please feel free to do so. We want this to be an interactive and helpful experience for everybody. Thank you.
Good afternoon, everybody. Thank you, Catherine. I appreciate that. We got a lot to cover. I'm going to go as far as I can with a lot of material for the next hour and a half. We're recording this session, so that'll be available to everybody after the presentation. Also, my slides will be available after the presentation also. And I also have some tip sheets if you're interested. So as Catherine said, part of the fun job, part of my job is to sort of be paranoid and psychotic and think, what could actually happen? And in this context, with what my clients' data or their privacy needs or privacy concerns, and what could go wrong. Right? It's easy to figure out, what's right, but the idea is to figure out what can happen or what has happened, and try and anticipate that so that we can prevent it, or at least, try to minimize the risk or the exposure of it. So in the context of data privacy for nonprofits, probably everybody's either been to a seminar on data privacy or heard of seminars or listened to something about it. So a lot of what I'm going to cover today is not the basics of, okay, here's what data privacy is, but try and give the context, especially since I assume that almost all of you are attorneys, either in-house or with law firms, and sort of give an idea of more of the compliance and how things affect you. So the first thing, at the end, I'm going to try and do as much as I can here in the context of nonprofit businesses. So what's the impetus of data privacy and urgency now versus 6 months ago or 4 years ago? Now, attacks on nonprofits are proliferating, particularly ransomware. Even though you think that nonprofits aren't real big targets because they don't have the data or they don't have the money. Wrong. They do have the data, and a lot of them do have the money, or they really don't care. They figure insurance is going to cover it anyway. Also, the laws are changing rapidly, like no other area that I've ever been in my career. And with it comes rapid changes in compliance requirements. Now, your privacy policy that's a year old is woefully out of date now. Okay. Now, I've seen them that are 2 and 3 and 4 years old that just don't even really relate to reality anymore because things have changed so much. Fines and complaints are increasing. Nonprofits are collecting more and more amounts and purposes of personal information and other kinds of data. So the result is you have to know how data affects you and how you affect data. How data affects you is it improves your ability to reach more people in your community and effectively manage and get out your message. It improves your ability to design better services and programs. It's also a liability risk. I mean, data can affect you because you've got something now. It's basically a ticking time bomb, and you got to manage it in case of a breach or a case of misuse. It's just something sitting there waiting to cause a problem if you don't need it for something. How you affect data is really, how you take care of it, how you secure it, how you share it, how you transfer it. So all these things are context of how counsel has to think about their clients. So as a brief part of it, since the definitions have been changing over time, personal information is basically any data, either itself or combined with any other data, directly or indirectly, that can identify or be used to identify an individual. So you see on the screen various types of data. And the types of data that are considered personal information, or PIs, we'll probably call it several times, is increasing, and the level of security has been increasing for different types. So, for example, geolocation. Recently, since the Supreme Court's Dobbs decision, geolocation information has been used by some pro-life groups to see if a person has visited an abortion clinic. Okay. And that sometimes that data is, you can get that data, or if you're a company that has got a customer or a vendor that does acquire that data, it can be used and misused. There are now things called sensitive or special categories of personal information. And this is particularly applicable under Europe's GDPR and also under California's new data privacy law. We're going to talk a little bit about both of them, both those particularly, but there's only so much that we really want to cover or can cover in one seminar, although we'll be able to have future parts, if we want to call this a series, that will cover the use of data under GDPR. Again, we'll talk about the laws later. So special and sensitive categories, which require more disclosure these days and more data privacy security requirements, are again, in addition to other sort of normal personal information, includes race and ethnic data, political opinions, sex life and sex orientation, health information, trade union membership, biometric like fingerprint, face print, voice print, and genetic data. Under GDPR, if your organization is in Europe, or I'm sorry, if it touches Europe and gets data from European individuals, the new requirements are you have to disclose the purpose for processing each type of sensitive data. Again, I'm not going to be covering GDPR in a lot of depth here because I would imagine a lot of the organizations that are participating today don't reach Europe, or really, it's a special situation. So the privacy laws that are affecting nonprofits are all over the board, as you can imagine. The state laws are patchwork. The new laws that are coming online this coming January, or this in 2023, include Virginia, Colorado, Utah, Connecticut, and the new iteration of California's privacy law. Of those new ones, only Colorado does not exempt nonprofits. The other new state laws and California all exempt nonprofits. You don't have to worry about them. In Colorado, you do. And as you probably know, data laws affect you not from where you are located, but based on the data you collect and where the person resides. That's where you want to call it the reach or jurisdiction is. So if you have members or patients or donors, et cetera, and you gain their data and they live in Colorado, you're subject to the Colorado law. Federal laws, again, there's a number. I'm sure many of you are already looking at these from the medical and under HIPAA. Financial, if for some reason you're involved with that, is Gramm-Leach. If you're involved with children, you've got COPPA and FERPA. You've got the Telephone Consumer Protection Act, which will cover or require compliance for telephone calling for marketing, but also covers texting. So if you are texting your members or you're collecting cell phones and you want to be able to text your members or your patients, your clients, your customers, you need to have permission or consent to do that, and you need to have the required disclosure under TCPA. So TCPA is not just a robocall statute. Obviously, you have the foreign, again, depending on where you're getting data from. All right, so you got GDPR, which is in Europe. There's a companion or a very similar one to that in the United Kingdom and also in Switzerland. Canada's PIPEDA privacy law, and obviously others. If you're getting data from China, there's laws that are covering that. And also standards organizations. The most predominant one that might be effective to you is the payment card industry, which is for credit card data. If you are still collecting credit card data, meaning the full credit card number yourself, as opposed to a third-party processor, make sure that you are complying with the payment card industry's PCI rules. They are not easy to comply with. They are a pain in the neck. Right? Hopefully, you're all using a third-party payment processor, and all you're getting is the results of the transaction, but not the credit card data itself. If, however, you are collecting credit card data, such as donor or membership renewal over the phone, make sure that you are treating that data very, very carefully. if you're saving that data, such as for annual renewal or something, you're going to be subject to the PCI requirements and compliance and audit and the certification. If you are just taking the number over the phone and directly entering the credit card data in your own web form because the person perhaps wasn't near the phone, you're not storing that data. You're entering it directly into your payment web form, example for donation, even though you're taking the information by the phone. But if you store that information, okay, now you got to deal with that. And the payment card industry rules are pretty intense. So other areas of compliance. So who else do you have to worry about, or what other organizations or what other influences do you have to worry about in terms of compliance? One area is grantors. The Pro Bono Partnership of Atlanta, we gave a seminar a couple of weeks ago for grantees under a major program. And the grantor can sometimes require certain data handling, right? Usually not much different than what a normal relationship would be, but you have to be aware that the grantors can lay requirements on you too for compliance with the grants. Customers and clients of yours, depending on who you serve, can also have requirements, at least like minimum requirements for you taking care of the data that you're providing them. Or more commonly, login credentials. If you're going to get access to the vendor system, a smart vendor will require you to take at least some minimum care of your login credentials in case you get hacked and someone can get in to the cloud-hosted vendor's database. They're not liable. Okay, so you got to worry about complying with that. Usually not a problem though. So customers and vendors, and then research partners. If you are sharing your data with a research organization pursuant to agreement, that research partner may have some requirements on that as well. So again, these are sort of the areas and things to think about for compliance. So for compliance steps, okay, first, determine whether you must comply. Do you collect personal information or PI of residents of the state or country? That sort of triggers everything. What do you collect and who do you collect it from? Do you have the right policies in place? Many of these statutes or laws or contractual requirements require that you have the right written policies in place. We'll talk a little bit later briefly about cyber insurance, and just to sort of mention it now, being compliant and also having written policies regarding data privacy and complying with them can make a tangible difference in the increase in your cyber insurance premiums over time. If they see that you are a better insurable risk because you've got yourself in good shape and you can show them these written policies, it can affect their judgment as to whether you're a good insurable risk. Conversely, if you don't really have your act together on policies and procedures, the insurance companies are now sending out a lot of due diligence questionnaires because they've had a lot of breaches that they're paying out a ton of money on, and they want to know whether you're an insurable risk. So you see these questionnaires coming. It's a good idea to pay attention to them. You're going to have to answer them, and you really do not want to have any misstatement on them because that is the fastest way for them to deny coverage in case of an incident, right? So if you don't even have an internal privacy policy in place, and you check the box saying you do, if there's a data breach, they're not going to cover you if they can find a way to not cover you. So do you behave as your policies require? It is worse to have a written policy in place and not comply with it than to have no written policy in place to begin with. So hopefully that's fairly obvious. As part of your compliance regimen for yourselves is do a gap analysis to understand what is versus what must be. Where are you right now in terms of your data security and privacy and your policies versus where you need to get to? And a lot of my clients, when they say, okay, so what do we need to comply with? All right. Well, often I'll say, look, you got the platinum level of compliance, you got the gold level, and you got the aluminum level. What do you want to get to? And almost invariably, my clients will say, just get me to the aluminum level. Now, what does that mean? Well, that means, that's going to minimize your likelihood of a negative, meaning a violation for which you might get fined, or a complaint under a private right of action, or breaching a contract. You're complying with the minimum amount that it takes to avoid having a headache later. But it's not necessarily going overboard. And I haven't met a nonprofit yet that has got so much money that it can spend to get to the platinum level. So as part of the compliance is to not just review your policies, but to revise or implement ones that need to be put in place. And probably the most important part of compliance, frankly, is training staff. And we'll talk about more about that later. So as you're having to look at yourselves and your data, in terms of privacy and what you've got, knowing your entire ecosystem, your environment of data is critical. And many, many companies, for-profit and non-profit, law firms, corporations, whatever, they think they know their data, but they don't, because it's so diverse and coming from so many different areas. So know what data you collect, and who you collect it from. Right? Data comes in from donors, from volunteers, from employees, from your clients, your customers, from website visitors, from conference and meeting attendees. These are all coming in different ways, and probably coming into different people in your organization. So know from what sources they're coming in from. Are they coming from your website, from your mobile app, email, phone, mail, in person, web form? Okay. So doing a data mapping exercise can be important. And Catherine, I believe I see a hand raised. Not looking at the chat yet, but please, if you have a hand raised, go ahead and Catherine, break in, because I'm not following that part of things.
Yeah, I don't see anything on the chat. We did have a top level question that I think you've been addressing so far, but I just wanted to mention it. Someone asked, when your response differs between profits and nonprofits, please, they would appreciate if you would note that distinction. Okay.
Sure. Yeah, see if I can do that. Again, for nonprofits versus for-profits, one of the big things to think about is basically California, okay, and now Colorado. That's going to be some of your biggest differences, because those are the two states where you have to sort of deal with that. So California excludes nonprofit or exempts nonprofits. Most of the other new state laws exempt nonprofits, but Colorado and GDPR do not. So if you're collecting data from individuals in Colorado or from Europe, I'm going to call Europe broadly, Europe, UK, and Switzerland, then you'd have to be concerned about that. Again, GDPR affects for-profits and nonprofits overall. So and again, I can see some of the chat here. Does California exempt all nonprofits, including hospitals and universities? California actually does not. It does not talk in terms of a quote-unquote nonprofit or 501c3. They talk about a business, and there's a definition there about what a business that is not, and they refer you to a different definition, a different statute actually. But typical, again, nonprofit, hospitals and universities. If they're nonprofit, they're nonprofit. It's a business that's not run for the benefit of the shareholders and other parts of that definition. So the definition is not really obnoxiously weird or even different. It's a pretty standard definition of what a nonprofit is. But you can be a nonprofit and not be a 501c3. But by definition, a 501c3 is going to be a nonprofit because it's not run for the benefit of the owners or shareholders. So back to data. So knowing from what sources you're getting things from, knowing where and how your data is stored is critical. Where is it? Is it stored locally? Is it stored in the cloud? Is it stored on a Google Drive? If it's on a Google Drive, are you using two-factor authentication, which I hope everybody is doing, but a lot of nonprofits are not, especially in small nonprofits, are often sharing things very easily because it's easy to set that up. But Google Drive is not as particularly secure, or Dropbox, Box, or OneDrive, et cetera. If nothing else, make sure that you're using multi-factor authentication, which means that you not just have to have the password, but you're also using an app or something, an email or a cell phone number to whenever you log in to get a second requirement to minimize the chance that somebody else is trying to hack in.
And Jason, we had another question on
Please.
comments. If you have any comments on the proposed American Data Privacy and Protection Act, House Bill 8152.
I don't, for the simple reason that it's going to take a lot. I think personally, I think it's going to take a lot for this to be passed. There's so many competing interests from individuals and from companies, et cetera, that I think it's going to be a while before anything gets passed, especially in divided Congress. And that California has already sort of threatened, if I recall hearing something, that they don't want to have their law superseded by the federal law. So you can become a constitutional scholar as to whether this area is something that federal law can trump state law. Frankly, I followed a little bit, but I'm more interested frankly, in what's been passed, and I think this one's going to take quite a bit to get passed. And even if when and if it does get passed, and I'm certainly not opposed to federal law. It would make things a lot more consistent. It's probably not going to be as onerous as, let's say, California or GDPR, because it's going to have so many different lobbyists on both sides. And I use that in a positive sense, that it got competing interests, that the only way it's going to get passed in a very evenly split Congress to a degree is this going to be something that will work, and it's going to be a compromise. I don't think it's going to be something that, like in California, the California law was passed like with 48 hours or some. It was just rushed like you wouldn't believe, and it had a tremendous number of holes. So I don't think that's going to happen with a federal law. But it wouldn't hurt to have a law, because that'll also enable a lot of other things to happen in terms of transfer of data internationally if there's more consistency. So
we had
please.
one more question
Sure.
to you, Jason, going back to comments on hospitals and HIPAA. The question is, if you're a hospital, you need to comply with HIPAA regardless of whether it's a for-profit or nonprofit, correct?
Correct. And California and at least several of the new laws coming online specifically exempt organizations that have to comply with HIPAA. Basically because they figure HIPAA is pretty high criteria in terms of data privacy. So if you're meeting HIPAA level, you're meeting California level. So if California specifically says that if you're covered by HIPAA, then you don't need to comply with the California CPRA. All right. So again, where and how data is stored, you need to know. And it is not always obvious, because in a small organization that's grown organically, the data, HR has got data on its server, and membership's got data on its server. And let's say if your organization that serves patients, the physical therapists will have data in their files. So you need to know where the data is and how to lock it down. So if you're inside counsel, you should be making sure that your people know where the data is and where it's stored. Because if you have an employee that starts accessing data improperly, someone is going to be getting in trouble. And I've had this happen. I can't tell you how many times when an employee can just go into the Google Drive and get all the information. And this happened about a week and a half ago with one of my clients, where there was a Google Doc that essentially everybody could get access to pretty much all the data, including patient HIPAA data. And then she supposedly emailed the data from her work account to her personal account on her last day. That's the kind of thing that you're going to be in trouble if you do it, if you allow it. So that kind of leads to accessing data. Who has access to your sensitive data? Make sure that sensitive data is accessible only to those who need it. Segregate employee data in a different area. Create different levels of access. If a receptionist needs access to certain data, fine. But they should not have access to the employee files or patient files, for that matter. Disable immediately access of person on leave, right? And I had this happen to me when I had my own law firm many years ago, that I terminated an employee for day trading back when that was more popular. And I told one of my staff, my office manager, to basically shut down the employee to be terminated, to shut down her computer while I was talking with her and basically terminating her. The office manager didn't. The employee went back to her desk and started deleting all sorts of stuff. And I went to her office and I saw what she was doing because the keys were flying around, and I literally pulled the plug on the computer. So if you're terminating an employee, that access needs to be terminated before or during the separation meeting, because at that point, someone's going to be really upset. The employee is going to be upset with you, whether it's justifiable or not. And that's the point where someone's their ethics and morals just say, I'm going to do whatever I can to get back at you. So, make sure the access is terminated. Or if you're a large organization, make sure there's a procedure for your IT people to be notified quickly of someone who's leaving and to terminate their access to everything. It should be done hopefully same day, but certainly by next day. Problem is that if you're terminating someone at the end of the day and they can still get access that night, they can delete files, they can copy files, they can do all sorts of stuff. So you might need to notify IT in advance, hopefully, so they know what to do. You obviously want to prevent sensitive data from being downloaded or downloadable. I had one client, a nonprofit, who had a temporary employee sitting at the reception desk, but she was getting phone calls from members who want to renew their membership, and she was taking credit card information. We put it down in a Post-it note and put that in her pocketbook. And we found out later that she was going to the store and making some very nice purchases with that credit card data. The credit card company is not going to like, if that happens, you may not be liable for it, but if you're getting credit card data, there's a problem. So in terms of data and data privacy, you need to look at the data movement. Who's using the data within your organization, how the data is being used, who you're sharing that data with, because that is going to bring in all sorts of issues, and when is data deleted. So the mantra is, if you don't really need the data, don't collect it. Right? In olden times, it was the question is data. What do we need data for? We know our customers. Yesterday, it's hey, data is great. Let's collect all this data. We'll figure out what to do with it. Collect as much as you can. We'll data mine. Today, it's collect what you need. The rest is a liability in case of breach. If you don't need it, don't collect it. If you're collecting, like doctors' offices still have on their form, a blank for a social security number. Why do they need it? They do everything off of date of birth. I never put my social security number down at a doctor's office. If you're collecting data that you really don't need, especially if it's sensitive data, if you're collecting social security number on patients and it's really not needed for any purpose, don't collect it. Right? It's data can be valuable, and it is valuable, but it can also be a liability in case of a data breach. So a non sequitur tip, just to see if anybody is listening and paying attention, is how do you avoid paying ransom for locked up data? And the best way, without going into a lot of details on breach response, is simple. Back up your important data more frequently. Backups are cheap. Data storage is cheap. Look at your data backup policy. If you got data that changes very frequently, back it up more often. The question to ask is, if we had our data locked up from ransomware and we want to avoid paying the ransom, right, which means that we've got to restore from backups, how much data would we lose if we had to restore from backup? And if you're backing up once a week, you lost a week's worth of data. Well, for some nonprofits, it may not be a real big issue. You can sort of figure out how to get it back. If your data is changing rapidly, you're having research things being done, and you're using that data in many different ways, and it's changing frequently, or financial stuff is changing frequently, donor history, back it up more frequently. Just change the backup frequency. You can customize that for lots of different things, like emails, for financial information. So if you can have your data backed up frequently so that you can tolerate not having a small amount. That allows you to have that ransomware hacker hit the road. Different issue is about extortion, about publishing data. Different story. Okay? But this is probably one of the best ways of being able to defeat a ransomware attack that's happened, is to be able to say, well, it's going to cost us time and effort, but we can back up more frequently and get it taken care of. All right, back on track. We're now going to get to some degree into documents and policies and the written aspects of things. We're going to cover in a fair amount of detail agreements. So there's a comment in the chat from Doyle Mullis. I think medical providers collect Social Security numbers so they can turn it over to collections if patient doesn't pay. Although I don't often see the notice for privacy purposes on the forms for collection, which is interesting. If my doctor doesn't disclose that they want my social because for collections, can they use that social? Can the doctor use that number because they haven't disclosed what they're going to use it for? Interesting question. But even though I have healthcare insurance, I don't think I've ever had in a long number of years any doctor's office say, "Hey, we don't have your social." So interesting to see what that's really needed. So on policies and documents, covering some of the basics initially here. A website privacy policy. All right, that's the public-facing one. There's an internal one as well. The website terms of use. So let's go back. The privacy policy is going to cover it discloses what you do, what you collect in data, what you do with it, who you share it with, and other aspects of it. And the key thing is that you need to disclose it, okay, what you're doing with the data. If you don't disclose it, you're not going to be able to get consent for what you want. And privacy policies are dynamic documents. Your use of data, how you're disclosing it, what you're using it for, changes over time. So I encourage you to have your privacy policy and your terms of use reviewed at least annually. Because if it's more than a year old, it's got a good chance of being out of date either with the law or more likely with what you're actually doing in your own data practices. So that's part of what is why you want to have these kinds of documents reviewed frequently. Same thing for website terms of use. Terms of use is basically for just casual visitors. It can be for customers. It can be for clients. Many different purposes. Your information security policy or an InfoSec policy is really a playbook of policies, sometimes about 15 or 20. And some are for the IT people specifically, such as how often passwords have to be changed, how long the password is supposed to be, data retention policy, et cetera. But there's also a set for all employees, which is often included in the employment manual or employee handbook, but often is, when you have your typical employee handbook, you'll see that they don't cover as much as needs to be done. Again, having an InfoSec policy for internal use allows you to show it and have your employees and volunteers, et cetera, agree to it, and also be able to show that you've got consent and that they're supposed to be following it, which means if they don't, you've got something to point to for discipline. Okay. Also, these kind of documents can be used for cyber insurance purposes to show the insurer that you've got these things in place. And also can be used to show your compliance with the law. If you get hit with from either Health and Human Services, if you're under HIPAA, or if you get hit by some state agency if there's a data breach, showing that you've made a good faith attempt to comply with the law and you've got things in place will really reduce the likelihood of having a problem with a fine or something like that. And part of that is having an incident response plan. What happens if things go wrong, right? And there's a data breach. It's nice to know what the procedure is. The employee handbook comes with it as part of what I've just talked about. The data retention policy is important because you need to know or you should have a policy of when do you get rid of the data. Pardon me, when do you delete the data? You don't want to have data lying around you don't need anymore. It's just a liability in case of a data breach. That's just more records that are going to be exposed. From a cookie notice, which applies to your website, cookie notices are becoming more prevalent. Under GDPR, you need to have one because you need to get opt-in consent versus in the US, which is mostly you can do what you want unless someone says no. So you'll see cookie notices in the US where you don't have to accept it. It's just a notice and you click off of it. There's no consent. In Europe, or websites that are focused to Europe, you'll see that the cookie policy has to have an accept. So you'll see them having accept all cookies, manage cookies, accept just the necessary cookies. But again, you have to consent, which is why marketing lists were decimated when GDPR came into being, because now all of a sudden you could not send communications from marketing without having prior consent. Right? So if you didn't have consent before, you need it now. So again, I think it's more and more the way things are going and will be going in the future is getting consent. Again, we'll talk about consent a little more next. So getting consent to use data is critical, especially on the attorney side, because it's simple. You can write the best privacy policy in terms of use, but if you don't get proper consent, it's meaningless. It won't be enforceable. Okay? So Uber got slammed a few years ago in court on its on the terms of use for its drivers, which was on this mobile app. And it was essentially small print. It was in light yellow on a white background. Clearly, it was trying to be minimized. And the court said, nope, that wasn't present or presented well. So there wasn't informed consent. So as I said before, GDPR obtains consent and requires obtaining consent before collecting personal information, meaning opt-in. Again, unless there's legitimate interest, different story. We're not going to go into that in detail. So consent requires, at the basics, proper notice and active action from the user for consent. All right, so not passive, meaning do not use pre-checked boxes for anything. And you see plenty of them being used. Uncheck the box, even though marketing says, well, if we have it pre-checked, they'll just skip over it and keep going. In Europe, the courts have been clearly holding recently that that's passive. If it's they need to actually do something. So don't have pre-checked boxes. Right? And you can use it as a box. You can use it in other ways. So we'll talk about that in a moment. So make sure that you have consent for collecting data, personal information type data, at all the gates, at all your data collection points. So if there's contact us, or a newsletter sign up, or join, or a shopping cart page, okay? You should have the consent click through there. You want to have it as a gate, meaning they can't submit the information until they've acknowledged and consented to the privacy policy. Make that clear. Such as, I acknowledge and I have read and agreed to be bound by the terms of use and privacy policy, and have links to both. So it can be a box we to check, or if you don't use a box, it can easily be by clicking the submit button below, I acknowledge, etc. So you can adapt it for use, but you want to make sure that you have this language above that submit box, or button rather, not below it, because people read down vertically and they will not see it. They'll click and then see it. You want to have them see it before it. Now, it's got to be free and ambiguous, which means just have good language. You want to have these gates everywhere you can. It's for all sorts of purposes. So the idea is to try and get it the right way.
Jason, there's a question about passive opt-outs in the chat.
So passive opt-outs, meaning Okay, so how do you passively opt out of something? So Kendall, can you put in the chat box a little more when you say passive opt-outs? If you're saying like by doing X, you opt out of something. Usually, if you're already opted in, if you want to opt out of something, you have to do something or request something to do. So I'm not sure where passive opting out would occur. Passive opting in is perhaps the greater issue, but passive opting out, Ken will put a little more in the chat, and I can respond to that. As I said before, don't minimize the presentation of language. Your marketing people are going to want to sort of minimize this because it just interrupts the user experience. It draws attention to it. It doesn't have to be red. It shouldn't be any smaller font than the text around it. Don't try and minimize it by having, again, like light blue on a white background or light blue on a dark background. You just got to stand up to marketing and say no. Because if it's not enforceable, the terms of use are going to be ineffective. In which case, if there winds up being a problem for some reason, maybe the class action waiver or jury trial waiver or mandatory arbitration provision will no longer be effective. And with new laws coming aboard, you must allow individuals to withdraw consent, basically an opt-out. Have at the bottom of your email, newsletters, and various other places. All right, so let's turn now toward agreements, which I'm sure all of you have to deal with. Okay, and this part of the conversation goes just as well for for-profits as well as nonprofits. There's probably not a whole lot of difference in regards, but it's all about relationships. And you, as the organization, you are there's interaction between you and a vendor. Sometimes you are a vendor, sometimes you are a customer. Right? So you're a customer, and the vendor might be the data hosting company, the website development company, the software development company, the database company that you're using. The marketing, like MailChimp, SurveyMonkey, those are vendors. You're the customer. You are the vendor in other circumstances where you're holding your patients, your clients, your customers, your donors, your members' data, and are acting on it. So in that case, you're a vendor. So a lot of this depends on the interrelationships. And different situations, you're going to be one versus the other. Okay? So knowing what you require your vendors to do, knowing what your customers require you to do, are going to be important. For example, there was a breach a couple of years ago by a vendor called Blackbaud, and they hosted the data and stored the data of a huge number of large and small nonprofits. They had a data breach. Okay? So what was interesting is, okay, what was the contract between Blackbaud and its nonprofit, and what was the liability provisions? Right? So know what the data is being stored and know your vendor relationships. So basic principle is to look at risk-based prioritization. What access is needed for sensitive data? Focused on the sources of threats and who do you want to do business with? Do a vendor assessment. Right? Again, your clients, your customers, your employees, your donors that have entrusted their data to you expect or will be expecting you to be vetting who you're sharing the data with. So do some assessment. I had a client a number of years ago, which had been about to hire an outside payroll service, and I was on the phone with him and asked who it was, and I just Googled him, and it turned out that payroll service had 3 data breaches within the past 18 months. The FBI was involved. It hit the press, right? And it, at least from the website information I saw, it didn't really look like that payroll company had been doing a whole lot to lock themselves down and prevent future breaches, right? Do you want to do business with a company that's had that kind of track record? So do an assessment of your vendors. Okay? If you're a large organization, you're going to want to use questionnaires. Make the requirements clear on security, on insurance, the ability to update data privacy and data insurance requirements, or data security requirements as the law changes. So other principles are, look at the likelihood of a breach and data exposure, right? The risk of a breach and the exposure in the event of a breach are two different things. So the risk of a breach might increase with the number of vendors you've given data to. One more source of potential hack. The exposure is the number of records and potentially what's the financial exposure. So with one vendor, if you're giving them 10,000 records today and 100,000 records by 2 years from now, the risk hasn't increased, but the exposure has in the event of a breach. So you'll want to look at the probability of exposure. What's going on here? What is this data being used for? And figure out what kind of protective measures to take. And also, what's the impact of a breach? If you don't really have a whole lot of data, and if it's just name and email, the harm that it could possibly cause could probably be reduced. Because you might have indemnification obligations to those third parties, or it might be the other way around as well. So look at, see what the importance of that software or that service is to you, and should they get data? So for example, if you have a software developer that's going to be creating a database for you, rather than giving them all your sensitive data to be able to integrate into it or to play with, can you create some dummy data, de-identified data for them to use, which will, not just reduce, but eliminate the risk of a data breach by them, right? And then when they turn it on and have live data being used, then maybe at that point, maybe the risk will change, or you can just basically, have the database ported over, and then you load your own data, your live data in, and you won't have to worry about it as much. So again, when they get data is also important. So handling risk in agreements is always a big topic for attorneys who have to manage the agreements, and they've got to figure out, okay, so what do we agree with? What do we not agree with? What do we agree to? What do we got to deal with? All right, so I developed an acronym for this and started thinking about how you manage risk and data. And it's IDATA. It's ensure, diminish, avoid, transfer, and accept. And that's, in the big picture, that's pretty much what happens in agreements regarding risk. So I stands for ensure. Okay? You can insure against it. You have your own insurance, cyber insurance, and you require the vendor to have cyber insurance. So you can have the risk insured against. D is for diminish. So you want to diminish the risk of data, meaning, for example, one way is to increase the vendor's liability cap or super cap for data. So it diminishes, hopefully, your liability or your exposure. Avoid, A is for avoid. Prevent, the customer or the vendor from transmitting or uploading personal information. So if you're the vendor or as a nonprofit, if you're getting personal information from people, do you need that personal information? Now, if you don't need it, don't accept it. If you're, let's say, a vendor or in the role of a vendor, don't take on personal information that you don't need. Tell the customer, don't submit any personal information. We don't need that as part of it. Don't have anything that's identifiable information. I'm seeing the text box that, okay, so Kendall has got a long one on this one. Kendall, forgive me. I'm going to let that one go offline for the moment so we can continue on this. So we have, again, avoid the risk. Don't take on the data. T stands for transfer. Move it off to somebody else. Get the risk onto the vendor so you don't have to deal with it. Make it the vendor's responsibility or the customer's responsibility, again, depending on your role. To become the customer's responsibility by simply saying, don't send us this kind of data. We don't need it. And lastly is accept, right? And, if all worst comes to worst in the agreement, you accept the risk for this. And if you're in the role of a vendor, if you're going to say, look, okay, we'll take on all these data security requirements, but we may need to reprice our services because we price them based on this level of security or this level of insurance. If you want us to take on more, we may have to reprice. So we turn to agreement provisions, which is a lot of what I do, is technology agreements and agreements involving data. Is, as I said before, vet the vendor, using whatever methods you've got for assessment. Definitions here are critical, right? There is not one uniform definition of what personal information is or what a security breach is. So focus on your definitions because the most important part of any agreement here. If the definition of a data breach is any actual or suspected or attempted breach, that's much broader than a confirmed breach of data security. So an attempted data breach, right, which is what some customers may want to have you be required to do, is ridiculous because there's attempts on your systems every single day, 24/7. That doesn't mean anything's happened. You want to have a definition of a data breach being, something which has affected the confidentiality or security of the data. When you're looking at agreements, first question to ask is, is personal information going to be involved? If not, you can sort of, put back your claws a little bit and not be quite as aggressive on it. Find out if personal information will be involved in the data transfer, or if they will have access to the organization's personal information. If not, you don't need to hit them with quite as many requirements than as compared to if there is going to be personal information. But you have to ask that question. And also, when is that personal information going to be used? Obviously, you want to restrict the use of the data by the vendor to, and this again depends on whose ox is being gored here. But if you're the customer and you want to restrict the vendor, think about whether you want to allow that vendor to use personal information internally for their own improvement purposes. Can they use de-identified data, your de-identified data, externally, for benchmarking or for reports? No vendor is going to say they want to be able to disclose your personal information to third parties. Now, obviously, make sure that the vendor can't disclose personal information to third parties for the third party's benefit. Lots of times the vendor will need to have their subcontractors get PI, but that's for a legitimate reason. Put a section in for information security requirements if there needs to be, such as a data protection or data processing addendum. It should be appropriate for the type of data involved. I see a lot of them, which is pretty much scorched earth because that's the most conservative approach. And it's a 25-page, 8-point font, and very heavy requirements. That may be completely appropriate. But if it's not, don't use the most heavy-handed sledgehammer because, number one, if you're the nonprofit and you're talking to a vendor or service provider, you want the service. They want to sell you the service. Make the requirements sort of meet the needs. So, have the liability cap be appropriate. If you're the customer, obviously you want to have the liability cap uncapped for data breach. Right? So if there's, any vendor is going to have a limitation liability provision. If it's services, it's usually something like 12 months fees paid or payable. If you're the customer, get it to be fees paid or payable, because if the breach happens, let's say in the first 6 months, and it's an annual contract, you don't want the cap to be just the first 6 months of what you paid for. You want it to be for the whole contract period, and you want to have exclusions from the limitation liability for things like data breach or breach of data security, breach of confidentiality, and the usual things like indemnification obligations, infringement, gross negligence, fraud, misconduct, etc. Those are the usual ones you want to try and carve out from any cap. So in terms of a data breach cap, One way to do it is just have, if you can't get it uncapped, is to have it be a super cap. So for those things that are just set of the exclusions, have a separate provision that says for these things that are excluded, the super cap will be 3x or whatever is appropriate. Another creative way of dealing with it, where you're dealing with more data and more money, is to scale the cap. So for example, one of our clients is a bank. The bank is providing financial services, basically sort of check cashing, et cetera, services to a large healthcare organization. And it took us 6 months to negotiate just the data protection agreement, which was 45 pages, 8-point font. And it all came down ultimately to the data breach cap on liability. So what we wound up creating finally was a scale. The bank was going to be getting more and more data, meaning more and more customer data, or number of customers over time. So we scaled the liability cap based on the level of, or the number of records that we were getting. So up to, let's say, 100,000 records was X cap, and it went to up to 200,000, it was 2X cap. So you can scale that as a way, because the risk is not increased, but the exposure has. A big one in agreements is that a vendor is going to try. I'm sort of presenting this at this point now, not even-handedly, but assuming that you're most likely going to be the customer in this relationship. But obviously, it's applying both ways. Normally, the contract's going to disclaim consequential damages, indirect, consequential, special, punitive, et cetera, et cetera. Most damages from a data breach are indirect. Reputation, hotline, there's all sorts of things that are not the direct result of the breach. So a creative approach here is, even if they, you have to disclaim consequential damages, et cetera, indirect damages, have something saying, direct damages for data breach means X, right? And define that so that it's clear what those damages is going to involve. And I have a list of about 15 or 16 different items to include in that. I usually include it as an exhibit, so everybody's clear. Otherwise, the vendors can be able to claim that direct damages does include a lot of the things that are the result of a data breach. Requiring cyber insurance. Okay? You want to make sure that your vendors have cyber insurance, again, if data is going to be involved. Don't count on your own. Why should you count on your own? You require them to have it. Cyber insurance is very easy to lose too. If you have a data breach and you're the one who's at fault, and you make a claim to the cyber insurance company, there's a decent chance your premium is either going to go up or you're going to be canceled. So why make the claim at all? Have your vendor make the claim on their insurance. Also, and it should be obvious, but require the vendor to comply with all applicable laws and regulations. It's one sentence, right? But it could open up a lot of avenues if there's a breach and they breach the agreement by simply not complying with laws. Again, where applicable, make sure you have the right to do security audits. Okay? It's becoming more and more important. And even if you're a small nonprofit, you at least want to have the right to go in there and do this. Moving on. Make sure you have a right to get a copy of your data on termination if you need it. If it's all data that you already uploaded, fine. But if they're either collecting data for you or there's data that's being created, you want to make sure that upon termination or expiration, that you can get a copy of your data before they delete it. And you really don't want to have to pay extra for it if it's something which they're just going to punch out and give you a data dump. A lot of times, there's going to be a need for transition services, meaning you need that vendor to help you transition or migrate to another vendor or service provider. You need to add a provision in here, usually in the termination section, the effects of termination. And if it's a software as a service or an online platform, your access can be cut off, right? And if you terminate or if you cancel for convenience, your access can be cut off. If you need to be able to migrate, you want to have in there a provision that says that the vendor will provide transition services if you request it for up to 3 months, 6 months, whatever, at the then prevailing rates under this agreement, or according to the rate card. But you want to require them, right, to provide this. And it's fine to be able to say that you're willing to pay for those services upfront monthly. Right? So the estimated cost of the migration service is monthly, and then you true up at the end of the time. Because the vendor, especially if there's a fee dispute, is not going to want to provide transition services. They want to just be done with you. So that's worth contracting for. You want to make sure that the vendor will notify you immediately and cooperate if there's a data breach. There's lots of sections on that. Obviously, make sure the vendor is responsible for the acts of his contractors. I see lots of agreements where this is not in there. Just a one sentence saying, vendor shall be responsible for all acts and omissions of his contractors and service providers. It should be normal, but lots of vendors don't put it in their agreement. And if you're reviewing the vendor's agreement, these are all things that we've been talking about so far that should be added. Force majeure. Right? So how would this be relevant in terms of data privacy or data security? So if the vendor has a problem and their data center goes down, they're going to claim a force majeure delay in providing services. Well, that's fine, but their ability to claim force majeure delay should not be allowable until they've exhausted their data their disaster recovery plan. And they sure ought to have a disaster recovery plan, meaning, okay, if their server goes down, if there's a flood, that they've got a backup server and a backup platform or service, somewhere remote, that will kick online within minutes or hours or a day. All right, any sophisticated vendor has got to have this to make sure that they have a disaster recovery plan, and that your force majeure clause says that force majeure cannot be claimed until the disaster recovery plan has been exhausted. Otherwise, they can just delay. Even if they have a disaster recovery plan, they can say, "Hey, delay because we got flooded out." As you're probably seeing a lot more these days is data protection agreements. I'm not going to go into too much detail because we could spend a lot of time on that alone, but you're seeing more of it. It's required under GDPR. It's required to some degree under California for nonprofits, for profits, and you're seeing more and more of them being used. And about 70 or 75% is fairly standard, right? But a lot of it is not, and there's all sorts of ways to slant it, depending whether you're the vendor or you're the customer. So don't just look at it and say, "Oh, these are the standard." And you might see the term standard contractual clauses. The standard contractual clauses are a GDPR phenomenon. Those are standard. Those are written in stone. Those cannot be changed. But usually the SDCs are attached to the data protection agreement, right? Which that can be changed. So don't just accept it and think, okay, well, standard, everybody's got a DPA and the SDCs are standard. No, because different obligations will be involved. So take a look at them. They require a lot of close look because you want to make sure that vendor is being obliged to do what you need them to do. So if you're a nonprofit that has meetings and conferences, I'm not just talking about a handful of people sitting at a table, but if you have events and conferences, make sure that you're restricting your exhibitors and sponsors' use of the data that you're giving them or that they collect. And this should be in the exhibitor and sponsor agreement. And make sure that there's a code of conduct for attendees and for exhibitors. So that, again, there's codes of conduct for virtual as well as for in-person ones. And the exhibitors have to be able to have good code of conduct, and for attendees too. You want to be able to kick someone out if they're not complying. So it's a good idea to have a code of conduct. And it's not just for data privacy, it's just generally that you can have something to point to. So, lead collection restrictions. All right, so you may be providing your members or attendees information, even with just name and email address, to an exhibitor or sponsor, maybe considered part of the package. All right, so you need to know what's going to be done with that, and have you gotten consent from your attendees to provide that data for those purposes. Now, what about leads that the exhibitor collects them on the exhibit hall floor? A badge scan. If the meeting is in Europe, be aware of GDPR requirements on this. So these kind of lead collections and lead restrictions, make sure that your exhibitor agreement covers this, because the exhibitor wants to use the data for anything they can, right? And they're not going to send an opt-in request to the attendees. They're going to say, "Hi, glad you could attend the meeting. I would love to set up a call to show you what we can do for your company." Right? And then you see how long that can go on. And then the attendee comes back to you and says, "Why did they contact me? I never gave permission." So just be aware of that. So sort of a short list, or maybe it's not so short, of action items. One thing is to review things. So we're looking, as we talked about before, review the privacy policy, the terms of use, make sure they're up to date and they're covering what you're actually doing. Your cookie notice, make sure that's compliant with whatever you need to comply with. Your InfoSec policy handbook, they one for general people and for the IT people. Your incident response plan. Does your incident response plan have a variant for ransomware? Right? 99% of the ones I look at do not. All right, ransomware is a different response than a normal data breach. In a normal data breach, you can still get at your data. In a ransomware situation, you can't even get access. So you can't even get access, not only to your data, you can't get access to the response plan. So make sure that your incident response plan has a variant for ransomware, and then that you're looking at that plan. Again, data security breaches are going to be rare, and certainly, hopefully, they're going to be rare. But like a fire, got to have a drill and be ready for it. Look at your template agreements. If you're a vendor or you're providing services, make sure you get your customer agreement. If you're the customer, take a look at your standard agreements to make sure some of these things are covered and updated, especially the data protection addendum we talked about. Just the routine NDAs and non-disclosure agreements. Make sure that again, if you're the nonprofit, you're disclosing PI, make sure that personal information is part of the definition of confidential information. Second, make sure in the duration of the confidentiality obligations that you have 3 lengths of obligation. Normal confidential information is to be kept, again, during the agreement, obviously, but after the agreement ends for whatever period of time you want, 3 years, 5 years, whatever, right? Data that's considered trade secrets, right? You want to have kept confidential forever, unless the confidentiality of that unless the trade secret status of that trade secret has been lost. Okay, you don't want to enable a by contract the trade secrets to no longer be considered confidential that were disclosed. You want them kept confidential. And personal information, the third category, you want that kept confidential forever, period. Okay? But you need to state that, because most confidentiality agreements that you'll see just saying the duration of confidentiality shall last for 3 years. After that, no obligation. Well, certainly there needs to be for personal information and for trade secrets. Again, most of the time, nonprofits don't have trade secrets as such, but certainly if there's PI being disclosed, got to be in the obligation to keep that confidential forever. Review if you're subject to data access requests. Again, if you're subject to GDPR or other state law, you need to be able to respond in case an individual wants to have their data deleted or amended or a copy of it or know what's been done with it. And these are called data subject access requests. So you need to make sure you have a policy and a procedure in place, some template responses, a logbook to make sure that you're keeping track of all this, how you disposed of it, did you vet them, make sure that they were the person who they say they are, what did you do? Also, as part of your overall review is to do a data inventory mapping assessment, like we talked about before. What data did you get? Where is it stored? How is it used? Who's disclosing it? You might need to do a data privacy compliance assessment under applicable law. Some places require, like GDPR requires that you do an assessment. Review your website. It's always a good idea to just take a look at your own website. I can't tell you how many websites I've seen that I talked about with the clients. They said, didn't know we were doing that, or didn't know we weren't doing that. So look for required notices. Look for proper click-through consent at all the points of data collection. An easy one here is look for, make sure you're ADA compliant. Right. As far as I know, ADA does not have any exemption for nonprofits. If it does, it's possible. I'm not familiar with that, but ADA does apply to websites. And there's a cottage industry of attorneys and law firms that send demand letters saying you're not complying with the ADA website guidelines, and there's a private right of action with obviously a monetary demand. So make sure you're ADA compliant. And while the ADA itself does not have the rules, there's something called the WCAG. WCAG, just Google it. And that's got the current, I think it's version 2.2, what the guidelines are for compliance. And a lot of it relates around images and how they're presented. So people that are sight impaired, when they scroll over it, will convert text to speech so they can understand what the images are. This is not as big an issue in the nonprofit area, but it's still one that crops up. So it's an easy one. It's an easy one to fix, sort of, depending on how much you have in your website. But it's all that better to be ADA compliant and avoid the issue, because if you get one of these demand letters and you're not compliant, they're tough to get rid of. Review your insurance coverage. We have a couple of guys in our firm that do nothing but cyber insurance coverage work, and they review policies to see, okay, do they cover what you need to have covered? And when it's coming up for renewal, what can you do to try and minimize the premium increases? Or if you have to rely on the coverage for in the event of a data breach, to make sure that the insurance company doesn't deny coverage. Or if they do deny coverage, have someone who knows what they're doing who can perhaps challenge that. Because with all due respect to insurance companies, which are needed in this world, the first thing they want to do is to try and figure out, do they really have to cover you? Okay. So among the last things I want to talk about is training. And as hopefully all of you know, training is important, period, end of statement. You need to train your people, because people train, people don't remember. So use the shampoo approach to training. Educate, meaning teach them what they need to do. Train them, meaning repeat the training and do it, and make sure that there's a training with exercises. Rinse, repeat. Okay. People change, staff turnover. People forget. There's free resources out there for doing exercises. There's also plenty of good companies that do this. If you're a large organization, you're probably going to be required to do some of these trainings, just like you are for HIPAA, for example. All right, last topic here is self-defense. And this is directed to you as an individual, not to your organization, not to your law firm. This is just things that you can do. And I find that when people can internalize what they need to do for themselves, they're more likely to do it for their organization, because they understand it more. So a quick run through, because we got about 10 minutes left. I'm going to do a quick run through of a short list of 10 personal tips that you can take yourself. And I've got a much longer list. And if you like it, please email me. Don't use the chat, email me, because that way I'll remember afterwards. Email me, I'd be happy to send it to you. So tip number one is freeze your credit. Most important thing you can do. And I could just stop right here. Freeze your credit with the four, not three, but four main agencies. Equifax, TransUnion, Experian, and Innovis. It's one of the most effective tools you can use, especially for identity theft. If someone can't open credit or take a loan out or take a mortgage out, they're going to really have a lot less use for your data. So it's not the same thing as credit monitoring, and the cost of it these days is minimal, right? If at all. I mean, it's a couple of dollars, if at all. Just go online, freeze your credit, freeze the credit of your family. Okay, it's easy to unlock it. If you're going to go in for a loan or you're going to go buy a car, you can do it on your cell phone. You got your password, unlock date. You can unlock it or thaw it for a day, 2 days automatically. It'll then refreeze or whatever you want. But do this because this is one of the most effective tools in the event of identity theft. And as for how to do it, easiest place, frankly, is to go to Clark Howard's website at clark.com. He's got a good credit freeze and thaw guide for more information on that. But nothing else, freeze your credit. Everybody should be freezing your credit. It does not harm your credit score to freeze your credit. Second, use strong passwords. No, use strong passphrases. Okay, forget this idea of having 6 or 7 or 8 digits because everything is so hard to remember. Use a strong passphrase that's unique. Like Ben loves baseball 22, right? And then when you need to change that password over time because for whatever reason, if you want to keep that passphrase, you just change the numbers. Okay, but you can just keep the long passphrase. The longer the passphrase, the more difficult it is, more creative. Don't just do row, row, row your boat. But the longer it is, the harder it is to break. But if it's something you can easily remember, it's better than just passwords. So use strong passphrases. Use different passwords for your junk versus important. Okay, for your financial information, for your American Express and your bank information, your banking accounts, use a different password than for other things which you're signing up for and have to create a password. That way, since it's more likely that the junk stuff you're getting might have a data breach, at least that password will not be able to be used with your American Express account. Okay. Change passwords. Nobody likes to do this because it requires you got to think about it, right? Change your passwords occasionally. Your Yahoo, your Gmail, they've all been hacked over time. Dropbox has been hacked. And you can go out there and you can actually go to a couple of websites, put in your email address, and find out if your password has been exposed. Right? I believe the website is spycloud.com. Spycloud.com. They're actually a vendor. I believe they're actually local. And if you put in your email address, they will look to see whether your password has been exposed on the internet, and it will show you your own password. Kind of scary. Disconnect your external backup drives to avoid a ransomware lockup. So if you're backing up your data at home, you might be doing it to the cloud. Okay, that's fine. You might be doing it to just an external drive. Make sure you got another set of that data on this external drive with what's called an air gap, and it's not connected to something. Because good ransomware software, will worm its way into everything that's connected online. Your computer, your partner's, your spouse's computer, your kid's computer, your backup external hard drive that's online. If you have it, and hopefully you're putting it like in a fireproof safe or say deposit box, with an air gap, they can't get at that. Again, another protection. There's one incident where some guy lost his Bitcoin number, like hundreds of thousands, if not millions of dollars in Bitcoin, couldn't find his password, right? Or the password was locked up, all right? So make sure you can get at it. Number 6 is don't click on links in emails, hover over the link to see. And if you hover over it and you see an address, which really doesn't make a lot of sense, or it's not .com, but it's like .ru or .cn, Russia or China, or just, there's a long string that doesn't seem to make sense, be careful about clicking on that. It's a hard one to figure out, but don't just click on links in emails. They're getting better and better at disguising it. But just before you click on that link, just realize sometimes you click on that link and you have just enabled software to be downloaded. Never use an unknown flash drive. This is hopefully passé at this point. I'm sorry, strike that. Never use an unknown flash drive because there are hackers that basically drop flash drives like at conferences. And you see on the floors, they were giving away, someone must have dropped this. You load it, bang, you just loaded malware. Backup routinely, don't need to say anything more about that. Install patches and updates for your own software on your phone. A lot of times there's security updates. Do it quickly. Don't wait, especially for Windows. Add your own email address to your own contact list. So if you're hacked, let's say your Yahoo account's hacked, and the hacker starts blasting emails out to your entire contact list, you'll at least get an email theoretically from yourself. You're gonna say, "What is this? I didn't send this." Had that happen several times with friends. So add your own email address as a contact. Don't use public Wi-Fi with your laptop unless you're using a VPN. Just be aware it's getting exposed, and it's a possibility. Is it likely? No, but you're in an airport. Everybody's using laptops in airports. There's plenty of people out there that know how to hack that. So at this point, we have a few minutes left. I am certainly here for questions. I hope this has been of some value or some use to you. It's been my pleasure, my privilege to be talking to the nonprofit section and whatever other sections are here. So I invite questions now.
Jason, there was that follow-up from Kendall about the pre-ticking the box for opting in. So if we have time, we could go back to that question.
Sure. So Kendall's question is, instead of pre-ticking the box for opting in, could pre-ticking the box opting out of data collection be an acceptable practice to regulators? Yes. Pre-ticking. I'm not sure in what context a company that's trying to send information would have a box saying, I don't want anything, and it's pre-checked. I'm not sure what the advantage would be in terms of active choice. I think a vendors might have the box saying, "Please don't send me anything," and you tick that box. But if it's not checked, then I'm not sure what the value of it would be. From Melinda. Can you please tell us a little more about Colorado's privacy laws and some basics about which we should be aware? All right. Colorado's privacy law is coming online, meaning it's going to be effective starting next year. It's got a lot of similarity to California's privacy law, which, in a couple of seconds here, involves, required disclosures the companies make, what they're doing with their data, how they're treating their data, what collecting their data, how they're collecting it, et cetera. All that needs to be disclosed. If you want, if you have service providers, you need to make sure that those service providers are under the right obligations, like California. For them to be a service provider, they have to certify that they understand certain prohibitions on what they can do with data. So Colorado is, I wouldn't say mirrored, but it's certainly patterned after California's law. But mostly what you want to be aware of is the requirement to disclose and get consent for your privacy policy in terms of use before you collect the data. So look at your privacy policy and make sure that it's accurate. You do what you say, and you say what you do. The worst thing is to be doing something with people's data that you don't disclose. Right? And if there's a private right of action, or if there's ability for the Attorney General to file a complaint, or to look at you, you want to make sure that your privacy policy is covering what you actually do, and what your vendors might be doing for you, including vendors like Google. At bottom line, that's what you want to make sure you're doing in terms of compliance, and also the data access rights of consumers in Colorado, which is somewhat patterned after, again, California. Consumers who are Colorado residents have the right to have access to information about their data, to have their data deleted, et cetera. Again, you might get a request from someone in Florida saying, "Hey, the law says you have to delete my data." Well, they're a Florida resident. There is no law in Florida requiring that. They might say, well, under California's, or Colorado's law, or GDPR, and throwing about terms, you don't have to comply if there's no law requiring you to comply. You may choose to comply anyway. And clearly, if they're still a member and they just are tired of getting your emails, but they want to stay a member, you might want to come back to them and say, we'll be happy to stop sending you emails, but you're a member. We still need your data to provide membership services. If they're terminating their membership, fine. But again, that's kind of the biggest things that most privacy laws are going to cover is disclosure of data, what you actually can do with it, what their rights are, what the consumers or the person's rights are under the data. Catherine, anything else?
I don't see any other questions. So thank you so much, Jason, for this incredibly informative presentation. We really appreciate it. And if anybody has any follow-up questions, please let us know.
Thank you all. I appreciate your time, your patience, and please, this is what I do for a living, is answer questions. So please feel free to contact me. I'm putting my email in the chat box, and it'll be on the presentation if you like it afterwards. Hope I just spelled that correct. There we go. Have a good afternoon, everyone. Take care.
Thank you, everyone.